Now, I'm afraid that this year it's the Silks who are going to hog the limelight during the talks. I'm looking to see Sean, who's up there. Now, Sean Wilken is with us on screen. Sean joined Chambers some 2.5 years ago now. He was a significant addition to Chambers' energy practice and energy offering. He was, for instance, leading counsel in the Seadrill Ghana operations and Tullow Ghana case in 2018. And what Sean does not know about force majeure, I think, is probably not worth knowing. Sean's going to speak to us about energy at the climate crossroads and climate change litigation. Krista and I will then speak about issues arising in the context of offshore wind farm disputes. And I know that Krista is going to touch on solar as well. The expansion in developing wind and solar as sources of renewable energy makes a review, it seemed to us at this time, pretty pertinent. Krista is particularly well suited to dealing with offshore wind farm issues, having acted for Greater Gabbard in its litigation against Floor. She could, for that matter, also speak about waste-to-energy projects, hydro, biomass plants, and the construction of nuclear facilities, but that is for another day. Last but not least is Lucy, who's going to do an update for us as to tiered dispute resolution clauses that continue to throw up serious issues, as is illustrated, in fact, by the fact that tomorrow one of our silks will be fighting it out in court on a strikeout application arising out of an alleged failure to comply with such a clause. Now, Lucy, as many of you know, has a well-established energy construction practice. You may recall, for instance, that she was junior counsel for Transocean in its hard-fought case against Providence, a case that remains central to the law on the interpretation of clauses excluding consequential loss, in that instance in the context of a drilling contract. So with that note of introduction, I'm going to pass to Sean, who's going to speak to us first, before I then launch into wind farms. Sean.
Thank you, Veronique. I hope everyone can hear me. My talk originally was purely about energy at the climate change crossroads. I noticed today, however, that energy security featured heavily in Prime Minister's questions, and indeed has featured since, because, of course, we are talking about the difficulties about satisfying current carbon demand and what will happen in the future. First slide, please, Marie. So there is a current tension in the energy sector. On the one hand, we have the oil and gas sanctions against the Russian Federation, which have obviously caused rising oil and gas prices. Indeed, I saw on my feed about 10 minutes before we started that Russia has now frozen gas supplies to several Eastern European countries. This is obviously going to lead to carbon demand, which means supply cannot meet demand, and so we have the spike in energy prices. This means, of course, that everyone is on the hunt for alternate energy sources, whether they be wind, solar, or indeed, again, as per PMQs today, allegedly one nuclear plant per year. Whether we see that happen or not is another question. But everyone is on the hunt for alternate energy sources. And so this raises the question, both in terms of law and geopolitics, about whether or not the major companies are going to be subject to what I call forced greenwashing. In other words, they're all going to be looking at how they become greener in their energy chain, both in terms of actually supplying the demand that they need to, meeting the demand that they need to meet, and downwards forces, namely government and or the courts, at which point we move to 3 cases. Next slide, please. What we've seen over the past year and a half is the rise in climate change litigation. And I use that word unashamedly. It's what the protagonists use. It's there. And we have 3 cases outside England and Wales. But again, in this sphere, we are international and we cannot ignore what's happening elsewhere. So the 3 cases are Agenda, Milieu de Foncy, and Visa Clamazac. They are cases in Holland and Belgium, but they're not less important in terms of their impact merely because they come from 3 particular states. If we can move to the next slide, please. Because what happened in these cases is the claimants plugged the energy supply stroke demand equation into the European Convention on Human Rights. What they said is, well, it's all very well that we have this energy which is available, but we think that the manufacture, using the term advisedly, of greenhouse gases, GHGs as I'm going to call them, causes problems with the ECHR. And it causes problems under Article 2, right to life, Article 3, freedom from inhumane and degrading treatment, and Article 8, right to privacy and family life. Now, breaking here briefly, there is, of course, a debate in England and Wales at present over the ECHR. There is also a respectable line of case law, see, for example, Ex parte Witham, that says that the common law is nothing more and doesn't need the ECHR because it protects anyway. And indeed, there's a decision today from the courts on this very point. So it's been pitched elsewhere in the ECHR, and it'd be interesting to see how the courts of England and Wales were to deal with it if it were to be transferred into the common law. Next slide, please. So why did these apply? So we have to start with the given that man-made climate change is occurring because all of the courts have said so. So whatever political standpoint we might have on man-made climate change, it's now taken as a given, certainly in European courts. And what the courts then want tend to look at is, well, what's causing man-made climate change? Answer, the courts again found as a fact, was greenhouse gases, GHGs. And what they then went on to say is these are causing a negative impact on communities now. In other words, we are seeing increased community expenditure on climate change mitigation, and therefore that is a negative impact on community. And it's now, it's not 2050, it's not 2060, it's not 2090. Next slide, please. So the first case is a case called Agenda. And where the court started, and this is again an interesting point, is it accepted almost as a given that the emission of greenhouse gases as a result of the energy sector was a threat to life. That was its given. And it was not particularly concerned about the scientific evidence about why that might not be the case. It just said it was a threat to life. Therefore, even though this was a global problem, each state had to do its part. And what we're going to see in these 3 cases is a theme about states having to do their part. And if a state has to do its part, then causation goes out the window. So you don't have to show direct causation by a particular state. And you don't have the defense that, well, this is all a global phenomenon and therefore this court in this state can't do anything. And what the court declared in Agenda, and of the 3 cases we're talking about, Agenda is now settled law, is the Dutch state itself had to cap emissions by 25%. So that was the court ordering the state to cap emissions. Next slide, please. We then have Milieu de Foncier, or Royal Dutch Shell. This is a big step forward in terms of the law, or backward, depending on which side of the fence you fall on. But what Royal Dutch Shell says is it's not against the state, it's against a private company. Now, in European Convention terms, that's huge. Because if you ask any human rights lawyer, does the ECHR bite against companies? They usually say no. They say it bites against states. But this is a massive change, and it's a change that could affect everyone who's dealing in commercial and construction law, because it's the deployment of the ECHR against a private company. And what it led to was a declaration that Shell had to cap its global emissions. And we're going to come on to a debate between scope 1, scope 2, and scope 3. But particularly here, scope 3, which is down the chain in terms of those with whom Shell contracts, all had to go by 45%. And the way the court did it was use something that every England and Wales lawyer will be well familiar with. They use the duty of care and standard of care. What they did is they fused the tortious standard of care and duty of care into the ECHR and said, hang on, Shell, you now have a duty to prevent greenhouse gases. And here we see again the do its part doctrine. It now kicks down to private companies. Next slide, please. So VZW is a decision of the courts in Belgium. And what it goes is it both goes forward and back in terms of how aggressive the law is being. It now says, well, actually, we don't bother about caps. We're going to instruct the state to mitigate. So the state is going to be told that it must mitigate the emission of GHGs. So that's not capping, that's do something. But it will be the state's decision as to what it would do to mitigate. Now, in traditional ECHR and international law terms, that's massively important, because what it says is, well, the state has what's known as a margin of appreciation or judgment or whatever as to what it does, in which the court won't intervene. And we've yet to see what the state is going to do in response to VZW. Next slide, please. England and Wales, very, very different position at present. So Plan B Earth tried to run these arguments before the English courts and failed abysmally, miserably, totally. They failed at permission, so they didn't even get through the first gate. And they failed at what would be a number of standard blocks in English law. So it was related to the Paris Agreement on GHGs, on caps. So, of course, the Paris Agreement says we need to cap greenhouse gases by these percentages by the following dates. The court said, well, that's an international agreement, we can't enforce it. The court also said, well, this is a massively political and technical decision, so we can't deal with that. And so the court adopted a massively deferential approach to the executive decision-making power in Plan B. We'll see how far that trend continues, but it is definitely one to watch. Next slide, please. What does this all mean? I think as litigators, as advisors, we have to accept that climate change litigation is here to stay, at least in the international arena. there was a massive article in the Financial Times in December of last year about the, if you like, the self-styled rock stars of climate change litigation. It's here, and that's not going to change. And of course, as we're dealing in the international arena, all global players may be susceptible. In England and Wales, that might not be the case. For those familiar with the Good Law Project, you will have seen recent cases where the court has been very sceptical as to its standing to bring pressure group litigation. And indeed, just this week, the GLP published legal advice about how that might change, how it regarded its lobbyist litigation mode. So that might be less likely in England and Wales. And I think certainly whilst Lord Reed is in the Supreme Court, there's going to be some resistance to pushing further on that. But international arbitration might be a more expansive area for these type of challenges. That's because there is an established theme in international arbitration cases about this, mainly looking at water rights, but also looking at pollution. So look at not only bilateral arbitration disputes, but also international investment arbitration. I can see being an area where this will definitely become an increasing point of argument. Next slide, please. As this is all pretty new, where do we look in terms of the future? Where do we look in terms of future challenges? New field, block licensing, block purchasing. I can absolutely see judicial review challenges, however you categorize them, whichever system, being brought to new field, block licensing and acquisition on the basis of climate change. That is undoubtedly going to happen. Indeed, we've already seen a couple in the courts of England and Wales. We're also going to see cap and trade requirements put into agreements, because in VZW and in fact in RDS, both the courts said cap and trade gets the energy major off the hook, and the government in fact. But that leads to a big issue. What is meant by a greenhouse gas cap? How far down the line does it apply? Who pays? How is that going to work itself out in agreements and litigation? We're also going to see, it seems to me, new obstacles to field exploration and development. At present, with the oil price being where it is, it doesn't really matter. But you can see the point in the near future where an increased greenwashing will force projects to stall. I mean, we've already seen one example of that. Shell in Dutch Harbour decided it wasn't worth pursuing with high Arctic development, and so took a massive hit to its top line of just parking the entire Dutch Harbour development and exploration from there. And obviously, you have the cost in times of management, legal cost, etc., of buying off or dealing with GHG emissions and climate change challenges. Next slide, please. The other two major issues, one is predominantly commercial, one is predominantly legal. The legal one is supply chains. We're already seeing massive tensions in supply chains. And whatever anyone else may tell you, I'm going to tell you that COVID force majeure is still happening. One of the reasons why certain costs are going through the roof is because China is closing its ports because it closes them down whenever there's COVID. We also obviously have the impacts of Ukraine. And both of those combined mean that force majeure is still a problem or still an issue. Indeed, it's one of the oddities of having been around as long as I have, is that subjects I thought were firmly off the agenda, like force majeure, restraint of princes, war clauses, etc., are now back in play. And that's what we're seeing both as a result of COVID and Ukraine. And then the really difficult one, the really crunchy one, is what do people do about scope 3, so that's supply chain, greenhouse gas costs? Where does it go? How is that legally taken account of? When there is a sudden, say, regulatory clampdown on GHGs in a particular jurisdiction, who bears the cost? I can't currently think of a wording that naturally deals with that. And so I think that is huge. And so if I were to be looking at developments relating to the greenwashing of energy, it would be three things. One, what do companies do about greenhouse gas emissions up and down the supply chain? In other words, how do they make provision for it? Two, what do they do about a sudden interruption of a contract by greenhouse gas regulation? And three, commercially, in the game of who bears the cost, who does end up holding the cost when particular greenhouse gases claims, stroke liabilities, stroke taxation come home to roost. Now, I've been slightly longer than I promised, so my apologies, Veronique. But thank you very much for listening, and I will pass over to everyone else.
Thank you, Sean. Offshore wind cases, current trends, and what the future holds. Now, although this remains a relatively young industry, it has been going for some 30 years. Yet it seems to me that we have relatively few cases that are in the public domain, directly illustrating the type of disputes that we have and continue to see that arise in this particular field. Why is that? It seems to me that there are two factors involved. Firstly, although the pool of players has been increasing, it's still relatively limited in terms of the number of turbine suppliers and main contractors, which one assumes means that there must be an extent to which the parties have to try to resolve their differences commercially. And of course, we're really at the coalface of dispute resolution, so we're the final goalpost, so to speak. The second aspect or reason, it seems to me, is obviously the preferred method of dispute resolution, which is arbitration. Disputes are dealt with behind closed doors. They're dealt with through tiered dispute resolution clauses, culminating in arbitration as the norm, and with a certain element of adjudication also, in fact, playing a role. And I won't say more about that because Lucy's going to speak to it. Now, many of the issues that arise and give rise to disputes are typical of disputes in relation to offshore installations. At a high level, you're looking at construction disputes, commercial issues. I ought to actually use the slides, shouldn't I? There we go, floating. Contract interpretation, regulatory disputes, planning disputes. Now, most recently, the EU has filed a dispute against the UK with the World Trade Organization, challenging the British government's subsidies for offshore wind farms. And that, of course, isn't really my bag, so I'm going to stick to some construction and commercial dispute issues. As I say, the nature and type of disputes are familiar to us, I think, as construction lawyers, and particularly to those of us who specialize in offshore construction disputes, whether they're about rigs or FPSOs or pipe lay, regasification, et cetera, decommissioning indeed. The nature of the disputes covers the usual issues concerning contract interpretation, delay, variation, scope of work, equipment failure, defects, commissioning, and so on and so forth. The contracts themselves are loosely based on logic or FIDIC forms And we, of course, are familiar with those. But there are difficulties that are inevitably going to arise, it seems to me, when you're applying contractual provisions that were developed over many years in relation to one particular type of industry to another, even if you're revising those clauses when you're drafting the contracts. Now, whilst the issues are, I think, typical of offshore construction disputes more generally, they're also, in a sense, overlaid by certain features that are, it seems to me, more specific to the offshore wind industry. And such issues are those that are driven by, for instance, the fact that it does remain a relatively young industry. The pace of innovation, which is something that obviously everybody talks about, and the development of the technology. And the third issue that I think is really worth raising, obviously, is the interface issues that arise because we're dealing with a disaggregated procurement structure in an industry. At least we often are. We're not always dealing with that. A disaggregated procurement structure is more likely to result in multi-party disputes, sometimes in different fora, where different dispute resolution provisions have been used in contracts between different parties. Who's responsible for what can become a very complex issue. Now, at the same time, the cost of these projects is huge, and the consequences of delay is significant, both in terms of things like sequencing the package, the work packages, vessel availability, and weather windows. Now, various institutional arbitration organizations, we know them, LCIA, ICC, and so on, have revised their rules to provide for joinder, consolidation, multi-party arbitration. My own experience is that that's very rare, very, very rare to see. There are other features which I think are specific to offshore wind. Take soil, for instance. We've been dealing with soil data and information being supplied by the employer, what we all call rely upon information, for years based on sampling, for instance, along a pipeline route to determine the nature of the seabed and that where the pipeline might be put. And of course, that's a sort of corridor. But with the wind farm project, you're not looking at a corridor, even if it is kilometres long. You are looking at a huge area, 100 kilometres square or similar. So obviously, what you might gather in terms of sampling data in one area may well not affect or tell you what you're going to find when you're actually putting down your foundation for a particular turbine in a particular spot. That might change, of course, and no longer be quite so relevant when we're dealing with floating offshore wind. Weather is another very big issue, a major issue. You might say it's bound to be if you're actually looking for the windiest place that you can put your turbine in. Standby at the same time for installation vessels and their support vessels is a very expensive thing. And there are only a very limited number of vessels that are capable of undertaking this sort of lifting work. And we've got turbines that are getting larger and larger and heavier, and we've got fewer and fewer vessels that are actually capable of undertaking the installation work. Another thing that I think is relevant is the application of technology that was developed, not just contractual clauses, but technology that was developed in one field that is in fact then being applied to another. And I'll give you an example of that in a moment. Now, I'm going to stop because that's a general introduction. And what I wanted to talk about is one or two of the more recent cases, or at least what's in the public domain. Now, you're going to be familiar with all of this because there aren't any very new cases in the public domain. Leading the pack is MT Hodggaard against E.ON in the House of Lords. That's a case that Krista is going to talk about, so I won't say more about it. The second and third cases that are identified on the slide are the judgments of Sir Anthony Edward Stewart in the floor litigation, and I'm going to come back to that. Gwent, in essence, is a commercial case concerned with the proper interpretation of an indemnity in a sale and purchase agreement. The regulatory framework that we're dealing with that governs how wind farms provide electricity to the grid requires the ownership of the electrical transmission link between the wind farm and the grid to be separately owned. Hence, the sale pursuant to an SBA of certain assets from the defendant to the claimant. Those assets including 4 subsea export cables. I put this little diagram up because I think it's quite useful to be able to see the wind turbines put together with their inter-array cables, which are pretty relevant, and I'll give you an instance of why those are giving rise to issues at the moment. Then the offshore substation, the export cable, and the onshore substation. That's the basic setup, shall we say. Now, this is a transaction that completed on the 17th of February 2015, and 2 weeks later, on the 2nd of March, the first cable failed. The second failed 6 months later. The cause of all of that was a latent defect in the sheathing of the cables. And the claimant basically relied on an indemnity that was in the SPA. Now, I'm not going to go through the case in detail. I've got a summary on the slides, which you can look at your own leisure. But in short, the indemnity provided that if any assets are destroyed or damaged prior to completion, the defendant would indemnify the claimant. Now, Lord Justice Phillips undertook a textual analysis in construing what the relevant contractual provision meant, and he came to the conclusion, for various reasons, that prior to completion actually meant as between exchange of the contract, signing up the contract, and completion, which was a period of 6 days. And that makes complete sense when you read the judgment. I think the point about this case myself is not the outcome of the analysis that the judge undertook, but how Lord Justice Phillips actually went about the exercise of contractual interpretation. Because it's very easy, and we do it quite often, it seems to me, to cite authorities on how you undertake this exercise of contractual interpretation. We can all talk about Arnold and Britton, or Wood and Capita Insurance, or Rainy Sky, and so on and so forth. And we set out those principles. Actually applying them, I know from sitting as a judge or sitting as an arbitrator, is much, much harder. And it's fantastic to read a judgment like this one, where you can really see the thought process and the application of the criteria in action. So I'd recommend that case from that point of view to anyone. Now, much more relevant in the context of this present talk, though, are Sir Anthony Edward Stewart's judgments in the Floor litigation. Floor, to my mind, is the paradigm case of the type of disputes and the complexity of disputes that can arise in this area. And in terms of the facts, many of you may well be familiar with them, so forgive me, but the dispute arose in connection with an EPC contract between Greater Gabbard and Floor for the supply of the foundations and the infrastructure for 140 wind turbines. They were offshore Suffolk. Now, Floor subcontracted the construction of the monopiles and the transition pieces to ZPMC, a steel fabricator based in Shanghai. And these were then shipped in batches to the Netherlands to be fitted where necessary with the relevant electrical components before, at least the idea was, being put onto specialist vessels for installation in the North Sea. The monopiles themselves are made up of individual cans of rolled steel plates, and they're welded together. Now, non-destructive testing, when these parts, components, non-destructive testing, I should say, of the welds in the Netherlands found cracks. And that occurred because the testing regime that they applied in the Netherlands was different to the testing regime that they had been applying in the Chinese yard. And that led Greater Gabbard to issue NCRs in relation to the first 3 shipments of components when they arrived. Now, as a result, the whole project was thrown into disarray. What was intended to be a staging post in the Netherlands becomes a major manufacturing facility at huge expense, where they are trying to correct this apparent defect. Now, in time, Floor and ZPMC decide that Greater Gabbard's retesting and repair requirements are excessive, and that the cracks do not, in fact, impact the structural integrity of the monopiles. And so I think it's in about late September 2009, they decide to go ahead with installation anyway. You then get quite a complicated arrangement between Floor and the subcontractor, ZPMC, they come to an agreement in which ZPMC assigns its claims for the costs of the additional testing and the repairs to Floor, so that Floor can pursue those claims against Greater Gabbard. Floor then waives its claims against ZPMC for the costs that they have incurred as a result of Greater Gabbard's non-conformance reports. ZPMC then gave Floor a warranty that the monopiles were good for 25-year life, okay? Now, there were then arbitration proceedings between Floor and Greater Gabbard, in which Floor lost, leading to a partial award and eventually to a settlement. Now, Floor then brings court proceedings against ZPMC. There are two very, very substantial judgments. In fact, there are three judgments, but two large judgments from Sir Anthony Edward Stewart in relation to the case. He holds that in breach of their contractual obligations and of their workmanship obligations, the monopiles were not fit for purpose. They're not fit for purpose because they could not, without further inquiry or investigation, be loaded onto the vessels for installation. This is despite the fact that eventually, or I should say regardless, it's subsequently established that they're actually fit for a 25-year life. Now, the scope of the issues in this case, it seems was clearly huge. The judge had to determine the cause of the weld cracks, the location of the cracks, the methods of testing, the repair procedures, the impact on of Greater Gabbard's NCRs, the reasons why the monopiles were not loaded out and installed. That's just the construction side of it. There were then numerous issues about contract interpretation in relation, for instance, to the meaning of the waiver letter that Floor had given at ZPMC, and with estoppel by convention, and the law, in fact, also estoppel by representation. He then had to determine the impact of the waiver on Floor's claims. That was just the trial on liability, because then there was 2 years later a lengthy trial on quantum in which the judge had to address some 15 issues, including, for instance, whether Floor could recover any of the sums it had paid to Greater Gabbard in its settlement with Greater Gabbard. There are some very interesting issues in relation to the correct approach to issues of delay, for instance, and causation, the application of the but-for approach, which led to the development of a whole counterfactual scenario in the case, which got very, very complicated, and issues about Floor's entitlement to recover the LDs that it had paid Greater Gabbard. And I know I, in fact, was relying on this case really quite recently in the context of an arbitration myself. Now, comments on the case itself, it's obviously clearly a case on its own, but it illustrates the complexity of these types of cases. It wasn't one problem that Floor faced during the construction phase of the project, but several, all impacting the works and all potentially relevant to determining the causes of delay. It illustrates the difficulties, I think, that are caused by the interaction between different parties. You've got arbitration going on in one place, you've got court proceedings going on in another. It illustrates the scope of litigation that's involved. It illustrates how commercial issues are intertwined with more traditional construction type issues. To give you an idea of the scope of the case, the liability trial alone takes 19 days with 20 factual witnesses and 6 experts. There's a 145-page judgment, and then a year, 18 months later, you have a trial on quantum, which takes 5 weeks with a 132-page judgment. So to my mind, it's a very good example of the type of disputes that one might be looking at. Now, of course, the issues in Floor arose out of facts which date back, some 12 years. So what are the current trends? Delay to projects caused by the impact of COVID on the supply chain is obviously still an issue. Yes, certainly, I think it's fair to say, at least in my experience, that a number of employers have largely been sympathetic to some of these COVID-related claims, but that has changed over the last year, maybe a bit more than that, with employers, for instance, being quite interested in what mitigation measures have you been undertaking or taking as a contractor. There are problems with the rely upon information in relation to soil, on one of the current projects that I'm aware of. Supply chain issues, Sean has obviously touched on that. It's inevitable, not least given the current geopolitical crisis with the war in the Ukraine. Supplies of components are already an issue. For instance, in relation to the HVDC cables, which are the cables that are running between, bringing the energy onshore, used to transmit the electricity, and query whether those types of issues are then going to change the method or the mode, I should say, of transmitting energy onshore if there are such significant problems in accessing and obtaining the cables, just by way of example. Defects and design issues emerging over time are also known to be a current problem, impacting the industry and the insurance market. For instance, the inter-array cable protection systems, I'd hope to find a photograph or an image in the public domain of this particular problem, because I have seen images, but I couldn't find one. So I'm going to have to explain very briefly what the problem is. What you can see on this slide is a turbine. Again, this is a foundation issue. And I don't know if you can see it clearly enough, but hopefully you can see the cable, the inter-array cable. These are buried between the different structures in trenches, but then they emerge from the trench on the seabed at the point where they're going to enter the turbine. Now, at that point, where they come out effectively of the soil and get into the turbine, they're protected by a cable protection system. And that's large polythene rings placed around cables. This is quite a common thing, which, anybody who's done oil and gas and so on has seen this type of protection being used on cables. Now, the protection I can show you, because I think I've got that. This is an example of the sort of protection that we're talking about. Now, the cable protection system has failed in some instances, and that means that there's then a failure of the cable. Now, originally, there was a scour protection on the seabed, then the cable, the CPS system, and then rocks were placed on top of the whole system, which stopped a lot of the movement. And then somebody decided, I think 6 or 7 years ago, from what I've read in relation to this, to dispense with the upper layer of rock, which means that there's been much more movement going on. And it's led to a major problem. We know, for instance, that Ørsted's reported, I think, the potential cost of addressing the issue in their UK and continental Europe wind farms at a cost of something like 403 million euros, and they were reporting that about a year ago. And that, of course, is impacting, as you can imagine, the insurance market. And then there's a big issue, of course, about who is responsible. Is it the CPS manufacturer, the installer, the designer, and so on and so forth? Now, that just gives you an example of what one of the issues that's currently running. As to the future, probably with a bit of light relief, well, I'll consult my crystal ball. There you go. Current capacity, there we go. A current capacity is approximately 10.5 gigawatts of offshore wind, with, it would appear from reports, some 4 to 5 gigawatts in the construction pipeline, which is different to the planning or the leases pipeline. Wind is the largest source of renewable electricity, apparently, in the UK. In 2021, the government were telling us that their target was 40 gigawatts by 2050, with 1 gigawatt of floating offshore wind. On the 7th of April, so a couple of weeks ago, the government announced in its British Energy Security Strategy a new target of 50 gigawatts by 2050, with 5 gigawatts of floating. Now, the British government's, the government's energy security strategy paper refers to us becoming, and I quote, the Saudi Arabia of wind power. It means, of course, presumably a lot more projects, presumably new entrants into the market. We need, it seems to me, to continue to think about transitioning knowledge and skills from traditional oil and gas projects to renewables. And the speed of that change is presumably going to increase significantly. Also, we've got to remember that it's not just us who are doing this. We know that wind as a source of energy is being developed in Europe and now in Asia as well. The extent, for instance, to which technology that's been developed in the UK or in the North Sea is actually going to work and apply in other subsea environments might be quite interesting. Presumably there'll be something of a challenge there. The pressures on the supply chains are also likely, obviously, it seems to me to be significant and to increase. And at the same time, you've got older installations that are throwing up their own challenges in terms of operation, maintenance, life extension, and decommissioning. In short, for my part, I can't see offshore construction disputes lessening. Rather, it seems to me that the planned boom in developing wind as a major or main energy source is going to provide fertile ground, I would have thought, for those of us whose business it is to either argue a case or to decide one. And on that note, I will pass to Krista. Krista?
Good evening, everyone. My topic is the designer's duty of skill and care. Now, I do a lot of energy work and a lot of renewables work. And very often in professional negligence, the question is always, well, did this particular consultant exercise sufficient skill and care? It could be, for example, just to give some examples, I did a hydroelectricity project. The question was whether the consultant had advised reasonably in respect of outputs given the government tariffs. I did a case about biomass. Was biomass sufficiently capable in this particular agricultural setting to cope with the different temperature differentials that were needed to grow chicks to fully fledged chickens for sale? Now, in the wind and solar environment, there are special challenges. You have got an uncontrollable energy source, be it the wind or the sunlight. There's also, it seems to me, an expectation in the wind industry that when we put these turbines out in the sea, that it's going to be low maintenance, that we don't need to go back and do any maintenance. And that's obviously driven by the fact that it's actually difficult to get out into the sea to carry out that maintenance. And the other challenge, particularly, is the advancing in technology. So the designer's duty, just looking at it, generally, the contractual duty, I've just picked up this contractual duty from NEC4, the designer is obliged to use the skill and care normally used by professionals designing works similar to the works. And in the context of wind farms, who are the designing professionals? What does it mean to apply a standard that refers to works similar to the works when it's the first of a kind, when it is the biggest offshore, when it's the first floating wind farm? And against, certainly in the English context, every contractual duty has a tortious collateral duty, and there's the tortious test there, the standard of the ordinary skilled man exercising and professing to have that special skill. Well, in the context of wind farms, we're talking about always exceptional designers, at least they're designing in exceptional circumstances. So my question really is whether these two standards are sufficient or really add anything to a designer's duty in the context of wind farms, really whether these tests really are fit for purpose at all in this context. Okay, so the first project, offshore wind farm project I worked on was Greater Gabbard. It was commissioned in 2012. And at the time, it was the world's largest offshore wind farm. There were 140 wind turbines generating enough electricity for 415,000 homes. And we thought that was big. And the challenge there, Veronique has already touched on this, but there was so much what I would call new technology, and there weren't any standards. So the problem with testing the wells in China and then in Vlissingen was that there wasn't a standard that said, this is the standard that you should apply to testing wells that are going to be used in the offshore industry. And that's why there was a conflict, because the Chinese contractors did in fact carry out the tests which they were contractually obliged to carry out. And it was only then when the monopiles got to Vlissingen, a different set of tests were being carried out. And at the time, it wasn't fully appreciated that the two different types of NDT testing would result in, were sensitive to different defects. Now, moving on from that, we now have Dogger Bank, which is now 3.6 gigawatts. This is a planned offshore, and it's to fuel 6 million homes. So we've gone from Greater Gabbard, 415,000 homes, to now 6 million homes. And what's interesting is obviously that was only in 2012 that we did Greater Gabbard, and now in 8-10 years, the technology has advanced so much. And for Greater Gabbard, you may know that the design life was there 20-25 years, and now we're expecting, the industry is expecting that we can build Dogger Bank with a 35-year operational life. So these are some of the challenges. And as Veronique has already said, we're now moving to floating wind farms, because the problem with fixed wind farms is that they're only really suitable for areas like around the UK, where the depth of the water is only about 70 metres. So when we go to floating wind farms, we then stretch beyond places like the UK, which have suitable offshore. So the possibility, for instance, of places where the continental shelf is much deeper, for instance, in Asia and around Japan. So what I read recently in a professional engineering magazine is that the Crown Estate in Scotland this year has approved leases for 17 offshore wind projects with a capacity of 25 gigawatts. And the technology is far from clear. So the platforms are to be floating, but they're to be tethered to the seabed, so that makes them akin to oil and gas platforms. But then how do you maintain the stability of these in the most wind areas, and where rotors for wind turbines are getting ever bigger? And no doubt the technology will develop over the next 10 years. And it's quite interesting to know, for instance, that shortly after the announcement about the Scottish project, the UK government announced that it was funding some 61 million into R&D projects. And just to have another pretty picture, well, what will it look like? We don't know. It's new technology. But one idea from this a Norwegian company, Wind Catching Systems, is that you could have dozens of turbines on a single floating platform. I was having a discussion with Veronique, and she was earlier, and she said, well, how is it going to work? Well, I agree, how is it going to work? And where are the standards for this? And what is, who are these engineers who are going to be designing these systems? Anyway, now, one of the reasons, it's interesting to look at what is driving the advances in technology here. Obviously, we have the whole climate change agenda. So there are lots of financial incentives from governments to invest in this sort of projects. There is a competition with other conventional energy sources in terms of efficiency and electricity generation. There's global warming there. And then the key players. Yes, historically, the UK has been a key player in the wind turbine industry, but obviously Denmark is also very big, mainly because of the DNV, I would suggest, and also now moving towards Europe and China. So when we're talking about the standards that an engineer has to comply with, what we typically look for, has an engineer complied with the standards, or what are the standards? And I've just put up on the slide there a few of the standards that an engineer may look to. The most important, probably in terms of offshore wind, is the DNV. Now, they're historically, obviously, big maritime research institution. They have lots of testing and verifications. They set the standards a lot in this area. And I don't expect you to be able to read this, but just to give you an idea, there is a typical offshore wind farm setup, and each of those blue boxes is a different set of standards from the DNV. And you'll see that for fixed wind farms, the whole project is covered. What happens when you get to floating wind farms? it's not covered. There may be some comparable standards that might be used for other offshore systems such as oil and gas, but really engineers are to some extent in new areas of research and development. So moving back to my question, who is the ordinary skilled professional in this context? I've already suggested before that what we've got are world-class engineers, because all these projects bring in, obviously, the research and development from around the world. Now, there are researchers at DNV who certify the different structures, and there is a question as to whether the designer on a project would be expected to be as skilled or have available to it this sort of testing and research facilities as the researchers do at DNV. Thirdly, are we talking about academics, professors at universities? And fourthly, I asked the question, well, when we're designing these projects, actually, is it down to one particular engineer with one particular field, or is it in fact an interdisciplinary team? So, for instance, in the Greater Gabbard litigation, you couldn't move for the number of experts. There was a whole team of them. And are we actually asking the wrong question to put one engineer in the witness box on these issues? And it impacts, it seems to me, these questions on how we conduct international arbitration. Because what we will find is that the witnesses, the actual engineers who have designed the project, are in themselves experts in the field. So then when we have experts, like arbitration experts, what is their function? Are they actually able to say, to give an opinion that I'm going to call him a jobbing engineer, didn't take exercise due skill and care? Or is the function of an expert, an impartial expert, actually just to educate the tribunal? To say, well, this is the background or the context within which the actual jobbing engineer was working. Now, just to mention a bit about the Hogard case, which I'm sure you're familiar, but just to try and pick up these issues of professional negligence, who is the expert and what is the standard? The issue in the case was whether the gravity connections needed shear keys. And there were obviously lots of allegations as to breach of contract, but there was also an allegation that the engineer had been negligent. And the difficulty with assessing negligence in this case was that there was an error in the standard, J101. Now, the experts in this case, we had a Professor Dr. Peter Schaumann. He was a chair at Leibniz University. He was head of Institute of Steel Construction. He'd done a PhD in numerical simulation of steel members and frames exposed to fire, and he'd been involved in the wider energy industry for several years. And in fact, he'd done a research project on gravity connections for monopiles for offshore wind turbines. Not, I suggest, the ordinary skilled engineer. But the difficulty is that experts in this sort of case play two roles. Yes, he is to set the standard for an engineer, but also to give the tribunal advice about defects and potential remedial works. So experts do wear two hats. And the defendant's expert was Dr. Colin Billington. He had 35 years experience in designing and certifying grouted power connections for offshore structures and offshore wind farms since 2008. And he was involved in experimental wind farms that had been constructed just as a research project. Again, a very eminent engineer is how he was described by the judge. But actually the judge said of Dr. Billington that his standard was too high actually for the jobbing engineer. And it's quite interesting when you read the case. It was a Rambo engineer. He was a civil and structural engineer. He actually started off in the oil and gas industry and moved it over to offshore wind farms. And the judge was obviously impressed by him and what he had done. He had followed the DNV standard. He knew that if he had suggested putting shear keys in, that there'd be a lot more experimental verification that were required by DNV to issue certificates. So he didn't, he just followed the standard. And the judge said that that was good enough almost to rely on the verification certification by DNV, which we all know is different from, for instance, a domestic situation where engineers are not allowed to rely on certificates from building control or NHBC or anybody like that. But in this context, I think the courts do appreciate that this is unusual circumstances and this is state-of-the-art designing. Now, if the standard of due skill and care isn't fit for purpose in this context, what we see is that the contract's actually developing and there are other, obviously, contractual standards. Fitness for purpose, design life obligations, which is the one. So fitness for purpose succeeded at first instance in MT Hogard because the monopiles were not fit for their 25-year design life. Then there's a design life obligation, which was discussed at length in the Supreme Court. And then what I've certainly seen in these contracts for offshore wind farms is the employer's requirements become more and more detailed. Yes, they all mention compliance with technical standards. And finally, there's this idea of extended warranties. I just want to raise a question here. If we're putting in extended warranties instead of a normal engineer's duty, skill and care, what is a defect? So in the Fleur case, there were cracks in the wells, but were they defects when in fact the structures would still meet the 25-year design life, that there wouldn't be a catastrophic failure? Now, just to mention quickly something about solar power, this is half of wind, so not as big as wind. And whilst there are similar issues with new technology, it's not as much. The most advanced technology, these photovoltaic panels, but there is still this expectation, as in wind farms, that we're going to have a design life and we're going to be able to just put these panels up and we're not going to have to touch them and they will perform for 25 years. I've just put there this note about snail trails on this question of what is a defect. Because lots of these panels, and I've had experience of this, exhibit snail trails, which are a visual defect. They look like snail trails. But there is an issue in the industry, and there are loads and loads of academic papers as to whether they actually affect the performance of these panels. Now, I'm just going to highlight for you one case, Toucan Energy, because it's the only case I could find about solar farms. To sort of echo what Veronique says, why have we not got more disputes in this area? It's an enormous judgment of 300 pages. But there were defects in the transformers and bus bars. The experts were a Dr. Lockwood, who was not experienced in the design of transformers for solar parks, which is interesting because you're meant to judge a design by reference to other designers in similar industries. But nonetheless, the judge obviously felt that he had been cross-examined too harshly by the claimant team and made a point of saying that although he hadn't got a lot of experience in solar parks, his electrical engineering experience was sufficient. And just a footnote before I let you hear Lucy, this case is very interesting in terms of blight, because we see defects such as snail trails, such as cracks in wells, which we might think would affect the value of the energy system because it looks defective or it's had a history of remedial works. And so in this case, there was a claim for many millions because even if there were remedial works, the whole system of farms would be blighted. A look at the judgment, the judge rejects it because he says, my job is to determine whether there are defects. I've decided that there are defects, but I've also decided this is the way you're going to remedy them. Once the defects are remedied, it follows that there isn't any blight. I'm not sure it works, but it's a very interesting judgment, I think, because certainly offshore wind farms, it's certainly the case that there could be defects out there that the parties know about, but because of their situation, you're not going to send ships, divers out to fix them. And is there an alternative measure of damage and loss in that situation? Anyway, I think where I certainly reach is that the ordinary standard of skill and care, it contractually worded or based in tort, is not fit for purpose in terms of these new technologies in the energy sector, and that parties need to take greater care over contractual obligations. But then that's all very often the employer to say, but the contractors also need to be aware of that risk in that situation that they are undertaking to potentially have to carry out the sort of verification and analysis that you would expect actually of a R&D house like DNV. So I'm now going to move on to Lucy.
This talk has the most boring title of any talk I've ever done in 20 years at the bar. I've done it a couple of times now. I asked for suggestions as to how to make it more interesting. And I did have a couple of quite good ones. One was No More Tears. And the other one was Stairway to Heaven ? And I haven't nicked the ideas. I've just told you about them. 20 minutes till drinks. And I promise I'll be on time. Everyone in this room knows about multi-tier dispute resolution clauses. I've done a sort of pictorial version of them on this slide. They are of varying levels of complexity in energy contracts. People tend to put in quite complicated ones of lots of different tiers, often involving escalating gradually up the company, and sometimes having a dispute resolution board along the way, etc., etc. And you get provisions that some bits of them are stated to be conditions precedent to the next stage, or sometimes to starting formal proceedings. And it is when they are stated to be a condition precedent that things get interesting. And I think it's pretty clear from the talks we've had so far this evening that we can all look forward to lots and lots and lots of work arising out of energy projects. And so it's no doubt we'll all be looking at these kind of clauses frequently. So first of all, I'm going to look at them in the context of court proceedings. And there's a pretty old case called Walford, which says that agreements to negotiate are void for uncertainty. So in principle, if you're agreeing to discuss your dispute, that's not an enforceable clause. But there are lots and lots of cases that make really very significant inroads into that proposition. And I've just picked a couple of them. The first is Cable and Wireless, which is Coleman J in the Commercial Court back in 2002. And you've got a mandatory obligation to attempt in good faith to resolve the dispute using a ADR procedure as recommended by CEDA. And so there were two bits to the obligation, and Coleman J found that it was an enforceable obligation. And he said that the fact that the clause finished up by saying that the ADR procedure wouldn't stop you from issuing proceedings did not mean that that was inconsistent with an intention to finish the ADR only at first before you went off to court. And they'd gone further than a mere agreement to negotiate because they've identified a specific process. And it was enough that the procedure was going to be the one recommended by CEDA, even though it didn't specify what that procedure would actually be. And Coleman J, rather ahead of his time, I think, in 2002, said at the end, English courts should nowadays not be astute to accentuate uncertainty in the field of dispute resolution references. So really that phrase could have come straight out of the Supreme Court cases like Wood and Rain Sky and so on, saying that if commercial parties make an agreement, then that's going to be upheld. And there's a series of subsequent cases basically following the Coleman J approach and upholding the enforceability of a specific negotiation process. And there's a Court of Appeal case called SulAmerica, where the clause was seek to have dispute resolved by mediation, which you may think is not that different to this clause, but that's what it said. And in the Court of Appeal, Morbic LJ said that's not good enough. it's too uncertain because there's no specific procedure referred to. So the cases are pretty consistent, and there's a more recent one called OPEN, which is one of those really useful cases where O'Farrell J has reviewed the previous authorities and distilled down the principles into 4 clear points. So you don't have to go and read all the other cases. You can just read my slide because these are her 4 points. But if you need the discussion of how it came about, it's in this lovely judgment of O'Farrell J's. And she, what's interesting about OPEN is that the principle set out, unsurprising based on what the authorities said. She looked at these 2 clauses together, 11.1.2 and 11.2, and held that there was a condition precedent set out by these clauses, so that the requirement to go off and use CEDA mediation was a condition precedent going off to legal proceedings, because 11.2 says if the dispute is not resolved, then you can go off. So she says it doesn't have to be the words condition precedent don't have to be used if the clause is clearly making one thing a condition to another. Now, there was no suggestion in any of the previous authorities that when the court was looking at a clause which said that a particular form of negotiation or mediation or so on was a condition precedent to issuing proceedings, that actually stopped you issuing your claim form and prevented the court having jurisdiction. So if you were coming up against limitation in court proceedings, what you did was you issued your proceedings and then you asked for a stay so that you could comply with the dispute resolution procedure that you haven't managed to do before you had to kick off because you were up against a time bar. And OPEN is also a useful judgment because O'Farrell J discusses the exercise of the discretion to order a stay, and she talks about when you will grant it, how long it will be for, etc., etc. And she what she actually did was she ordered the stay, but she ordered the parties to submit pleadings before the stay would kick in, because she wanted the dispute resolution to be effective, and she said it would crystallise the disputes. Now, I think that's quite a sort of amusing judgment of Solomon answer in the particular case, because quite often when you're the party that wants the stay, you're actually trying to kick the can down the road a bit. You're not actually ready to start litigation at all. You've only issued because you've got some kind of time pressure on you. And I think she nicely balanced the requirement to not allow the case to be kicked down the road, but also to allow the contractually mandated proceedings to be gone through. Veronique mentioned in her introduction that Keating Chambers is applying to strike somebody out, relying on a tiered dispute resolution clause. He's actually the other side in the case is also a Keating barrister, senior junior in Chambers. So it's a Chambers bonanza tomorrow. And this is the case, hot off the press. It will definitely be reported. So keep your eye out for it. And in the clause, I have obtained certain arguments in the case using my wiles. And the clause in Kojima is as set out on the slide. And you've got an interesting clause which says mandatory dispute resolution procedure uses the word shall, and then the jurisdiction clause, which says that the parties will agree to submit to the English courts, expressly says subject to the provisions of the dispute resolution procedure. Now, that's not that different from the OPEN clause, right? It looks pretty similar. They're both saying you can only go off and do your litigation after you've complied. Now, the defendant is running the argument that this goes to the court's jurisdiction, not just to a procedural issue where after the proceedings are issued, you've got to have a stay so you can do what you're supposed to do. And that's never been treated that way before. It's never been treated as a problem from limitation point of view. Obviously, the defendant effectively may as well have a go, because if they win, then the other side is struck out for limitation purposes. And if they lose, well, so what, really? I mean, nothing really to lose. And the way the case is being put is purely on the contractual basis. So the case is being argued that the true meaning of this type of agreement is that the parties have agreed that the failure to comply with the ADR will prevent you from having entitlement to issue your claim form. And I'm going to talk next about some of the arbitration cases. And I think, although obviously not directly analogous, come back to whether some of the reasoning in the arbitration cases might actually be applicable to the court position. But on any view, it's going to be super interesting judgment. So in the arbitration cases, whether or not the ADR requirement is a true condition precedent to issuing arbitration was particularly important because Section 67 of the Arbitration Act allows an award to be challenged on the basis that the tribunal lacks substantive jurisdiction. And that is defined in a number of ways, but materially, that the matters submitted to arbitration have to be in accordance with the arbitration agreement. And so the argument that was run in these cases was that if you hadn't complied with whatever the required dispute resolution clauses said, you hadn't submitted the dispute to arbitration in accordance with the agreement. Therefore, the arbitrators had no jurisdiction, and you have a good Section 67 challenge. And because Section 67 only applies to awards, you then could have another bite of your cherry at the end of the whole arbitration if you've lost. So there's a few of these cases. One of the earlier helpful ones is Tang Grant Thornton, and they were applying the Sud-America principles when construing the clause in Grant Thornton, which sent you off to the type of tiered clause that we'd all be very familiar with, where you've got to go to different people in the organisation. And then you could only, after a certain time had elapsed, then you could go off to arbitration. And the clause had to be insufficiently certain to be enforced. So the Section 67 point didn't really come live. But there's an interesting couple of comments that I've put on the slide where the court was discussing the tension between wanting to give effect to what commercial parties have agreed, and the fact that they've agreed something really vague and a bit fluffy, and it's very, very difficult to hold them to know what standard you're holding them to. And so you don't, and the other comment I think is useful is you don't tick it off. It's you look at each clause in its own right. So then there was a couple of cases, Emirates Trading Agency cases, and this was I like this case because it's sort of commercial court goes mad sort of thing. It's Tier J, and the clause required friendly discussions, and he held that was an enforceable obligation, sufficiently certain, clearly total nonsense. And he accepted that all the authorities suggested he was wrong, including the Court of Appeal. And he says, TJ just hates it. He says, I want to uphold these requirements because they've agreed them. And the Walford and Miles decision is the original one that says that agreements to negotiate are not enforceable. He doesn't like it. And he says that, and the reason he managed to do this, how it wasn't appeal, I don't know, is that he says that the fact there's a time limit on the friendly discussions makes it enforceable. Basically nonsense, and all the other cases say so. Emirates Trading, having obviously had a good result in front of Tier J, then tried again in another case in front of Popplewell. So you can see it's another friendly. They've obviously got a version of their standard terms that they've got with everybody. So they try again, friendly discussions. Tier J says it's enforceable, and came before Popplewell J. And he dismissed the case on other grounds. So again, the Section 67 point wasn't really argued. And Popplewell J refused to deal with the point at all. But he assumed in principle it would be a good challenge under Section 67 if you hadn't referred in accordance with an enforceable ADR provision. And then we get to Sierra Leone and SL Mining, which I'm sure everybody in this room is familiar with. And in SL Mining, this very interesting distinction was made for the first time in the context of precondition to arbitration clause between issues which go to the jurisdiction of the arbitrators and issues which they say that they refer to it as going to admissibility. I think that's a terrible phrase. It doesn't tell you, it's really opaque to understand. They mean procedural issues by issues of admissibility. And the court in SL Mining says this distinction wasn't articulated until in English law, until the case called Offshore that I've put on the slide. And SL Mining has a big section discussing lots of academic commentary, which says that you shouldn't treat these condition precedents to arbitration as going to jurisdiction, even though they say on their face that they're condition precedents. And he says, no, they only go to procedure. So if you are up against limitation in an arbitration situation, then you can issue your notice of arbitration and ask the arbitrators for a stay to allow you to comply with your dispute resolution clauses, just like in the court authorities up until maybe tomorrow. They talk about in arbitration cases, it obviously would be quite odd if the parties had agreed to refer their disputes to arbitration, but that didn't apply to their agreement that they would negotiate or do a mediation or whatever it might be, which would then be referable to the courts. So you'd have this bizarre situation where you'd be creating, not expressed in the contract, a dual dispute resolution procedure that's not written down. And they also talk about, in the cases, the purpose of these dispute resolution clauses is obviously to try, what parties, the reason they've put them in is, we don't want to be bogged down in huge, heavy, expensive proceedings. We want to try and do a deal before it gets that far. That's why they're in there. It's not so you can have satellite litigation about whether you've complied. And there's a subsequent case after SL Mining called NWA and all the other letters, which came out just after SL Mining last year. And this was a case, I like the facts of this case, where the clause said that you had to mediate and they had to do it in accordance with LCIA procedure, so obviously enforceable, no problem with that. And the defendants of the arbitration refused to mediate over 2 years and then said, no, I've got a Section 67 challenge because the mediation didn't happen and we didn't comply with the mandatory clause. And the judge says at the beginning of the judgment, highly unattractive, but if correct, they are entitled to adopt it, which I think is, they must have known when he was reading out his judgment or when they got the draft judgment through, but they definitely lost when they read that introduction. And I think it's quite one of those things that judges say where you're being really unmeritorious, but I will decide the case fairly, I promise, just against you. So the finding was that the clause didn't go to jurisdiction, unsurprisingly followed SL Mining. And there's an interesting extra bit. There's a similar bit in this case where there's various quotations from the academic commentaries and from authorities in Singapore and so on. But there's an interesting bit where the judge, Calver quotes a paper from an American academic called Professor Paulson. And this academic is setting out what he says the test is, the test you can use to tell whether a particular condition precedent is intended by the parties to go to jurisdiction or whether it only goes to admissibility. And I think it's quite good. So I'm going to read it out to you. The simple question that's being suggested is, which make it easier to classify objections in all cases, is the objecting party taking aim at the tribunal or at the claim? Conditions precedent, such as participating in a conciliation attempt, pose no problem. They go to admissibility. And that's obviously because the clause is directed to discussing the claim, not directed at the tribunal's power to hear the claim. And the example that Professor Paulson gives is a clause which reads, any arbitration must be initiated within 30 days after it was agreed that the dispute cannot be resolved by negotiation. And he asks whether the 30-day deadline was intended to be a limitation on the tribunal or on the claim. If the former, it's jurisdictional. If the latter, it concerns admissibility. And Professor Paulson goes on to say, points out the question could better be posed thus. In the event the 30-day limitation was exceeded, was it the party's intention that the relevant claim should no longer be arbitrated by the relevant arbitral forum,
but rather in some other forum? Or was there intention that the claim could no longer be raised at all? It's clearly not the former, and so it's not a jurisdictional question. So I actually think that's really helpful. The quote is, the full quote is in the NWA case. I think it's paragraph 53. And I think that's worth bearing in mind, that there actually is quite a convenient, like, practical test that you can use if you're looking at one of these clauses, and they're different to the ones that are in these slides in the previous cases. So that effectively means that if you are arbitrating, you can go and issue your notice and you're up against limitation. You don't have to worry. You can just stop time running and then deal with your non-compliance with the ADR requirements after, in due course. There's obviously some caveats to that. The fact that they're not, these clauses don't go to jurisdiction, don't prevent the need for a dispute to have arisen before you can go off, issue your notice. And obviously sometimes these dispute resolution procedures require you to issue a notice at the beginning, and that's the trigger for the dispute starting and the other side disagreeing with it. So you might have to comply with some of the dispute resolution clauses to get a dispute going in the first place, some parts of the clause to get the dispute going in the first place. And you also don't, I think, really want to be the person starting the arbitration not having complied with any of the clause. There's definitely being the good guy is very advantageous, I think, in both arbitration and litigation, but particularly in arbitration is my experience. And then I think that some of this reasoning, and I don't know if it's going to be argued this way tomorrow. At the moment, the arbitration cases are not being cited in the Skellies for tomorrow. I may or may not have addressed some submissions to people in chambers about that, but I think some of this reasoning is relevant to the way the clauses should be construed in the context of court proceedings. That even though the clauses specifically say condition precedent to issuing proceedings, and that's the terminology that's been used in the cases, the commercial purpose of those clauses isn't to set a new limitation period or to prevent somebody from issuing a claim form. I don't think. The purpose is to do a deal before you have to start spending money on barristers. And it's going to be interesting to see whether the court takes that approach tomorrow and treats the clause, effectively reads down the clause so that or reads it in a narrow sense, so that it doesn't bite on power to issue, even though it says condition precedent starting proceedings.